Good evening. Welcome to our presentation titled Protecting Assets from the Causes of Long-Term Care, which is part of our Many Matters series here at the Champaign Public Library. I'm Eva Liu, reference librarian at the library. Thank you all for joining us tonight. I would like to introduce our presenter for the evening, Kaye Dent. She is attorney and managing partner for the Dent Coulson Elder Law, a downstate law firm focused on elder law, particularly long-term care planning, special needs planning, guardianship, and estate and trust planning. Please help me welcome Kate.
Good evening. I'm glad we have a nice little crowd here on what's not going to be a very pleasant night by the time I think we're all going to get out of here right before the weather ends. So I guess that's the good news. I am Kaye Dent. I am really happy to be living in Champaign. And as Eva said, my offices are mostly downstate. I have an office here in Champaign, in Effingham, O'Fallon, and Shelbyville. So I cover a pretty wide area, and my practice is limited to what we call elder law. And specifically for me, that means that I help people do their basic estate planning, but with a focus on not just what happens when you pass away, but what happens in between now and then, especially focusing on disability planning. Nursing home planning is a big part of that. I also help people plan for loved ones with special needs. As she said, guardianships and things that kind of all intertwine together in a lot. There's a lot of intersection there. So I'm going to talk to you tonight specifically about strategies for protecting assets from the cost of long-term care, because that is probably for the average American the number one risk to your nest egg. People I think still a large part of the population thinks, no, I'll never go to the nursing home, I'll stay at home. And that's just outright denial. We are an aging population. We don't have the family members available to keep us at home. And as we're aging, the people who would, the people who would traditionally be our caregivers are aging as well. So I'm seeing people who, when my grandmother always said she'd never go to the nursing home, and unfortunately for the last few weeks she had to, but she also didn't expect to live to be 92. Her parents had died in their 60s and 70s, which at the time in the 70s wasn't as that unusual. And by the time she really needed care, her 4 boys were all in their 60s and pushing 70. So things are a lot different than they certainly were for a lot of our grandparents or parents. And the reality is that as we age, more and more of us are needing care, and the costs are increasing. So it becomes a very big risk to the typical nest egg. I do want to remind everyone that this is not a how-to project talk. I'm basically here to give information and hopefully dispel a lot of myths, because there are a lot of myths out there about planning and how long-term care is paid for and what's actually at risk. I do encourage questions. I like to have questions as we go along. It's one of the reasons I don't use PowerPoints anymore. I haven't for some years, because I don't want you looking there. I want to have a dialogue. So if you have a question, ask it. I always get really great questions. I do also ask you to please not ask personal questions, because with the kind of planning that I do, every situation is unique. Everybody's a different age, married or single, divorced, they have kids, they don't have kids, the kids are grown, the kids are minors, the assets are all different. So I can't answer personal questions, and I really don't want to answer your personal questions or have you feel like you need to ask personal questions in a public forum anyway. So having said all of that, I'll kind of dive in. The number one way to protect your assets from the cost of long-term care is to get long-term care insurance. And I know that that's a bitter pill for a lot of people to swallow, because they think it's one more insurance. They think it's really expensive, and it can have a price tag to it. But if you look at the price tag compared to what you get for it, it can make sense for an awful lot of people. Years ago, when I was in my 30s, which I'm not anymore, my father was retiring and he was getting long-term care insurance. He took me aside. I was only 39 at the time, so barely in my 30s. And he said, I would really encourage you to get it now. I know it seems like it's really early, but I think you'll find it's going to be really cheap for you. And the industry has changed a lot since then. You can't get the plan that the one time I listened to my father, because, I'm an attorney, I'm kind of strong-willed, didn't always listen, but the one time I listened to him, I made one of the best financial decisions of my life by locking into long-term care insurance. But what he told me, the logic remains true even in today's market. He figured at the time he was going to spend about $2,000 a year on his policy, which still is not an unusual premium if you're relatively healthy and not beyond, a certain age. I think he was in his mid-60s, typical retirement age. And he said, if I spend $2,000 a year, if I go into the nursing home at the same age that my mom really should have, so 20 years from now, I will have spent $40,000 on premiums. But I'll get that money back in a few months because care costs thousands of dollars per month. And likewise, I had a girlfriend who was trying to talk her husband into getting it, and they have farmland. And she said he was digging in his heels, and she said, "Oh, that's fine. When you go into the nursing home," because he was a little older, "I'll just start selling off an acre of land every month, pay for your care." And they went and got long-term care insurance. So I do want to remind people that it is worth looking at, and it's free to go out and get quotes. You can get as many as you want. You can shop it around. You don't have to involve an attorney. That's completely outside of doing any legal estate planning. And it can really, really help protect your assets, especially if you have assets that you want to hand down to the family, like farmland. You've got to plan ahead. It's much more difficult to plan, and I think I see two questions I will get to in 1 second. It's much more difficult to do crisis planning. It's not at all impossible. I do it every day. But if you wait to plan until the need arises, you're going to lose usually half your assets, give or take. Even if you're married, that can be the case. There's just a lot at risk. So aside from looking at long-term care insurance and really encouraging people to get that if they can, I encourage people to plan ahead. Advanced planning will always save you more than waiting until the last minute. So there's a light blue shirt there. You had raised your hand.
Yeah. So what are some of the things you should look for when purchasing long-term care? What are some things that you should look for?
Fantastic question. One thing that I see people a lot of times with older policies not have that's really useful is an inflation rider. That means that most of the policies now, and I'm not licensed to sell insurance, so I'm not an insurance producer, but I have taken exams and stuff because I try to keep up on this so that I can give good information. And I talk to my insurance colleagues. The policies you used to be able to get were kind of Cadillac. And nowadays, what you're usually going to be getting is a policy that pays out a certain amount of money cap. So, and it's going to pay out a certain amount maximum per day. The inflation rider every year resets that daily maximum by 3 or 5%, whatever it is for your particular policy. Now, that may not be the same as the cost of care increases. None of us can completely predict that. But it does mean that if you buy a policy now that says it pays $275 a day, and later on when you go into care, it's $375 a day, hopefully it will have at least kept up for most of that. Another thing to look at is whether or not, if you're married, if the policy offers a spousal rider. I've seen those where if your spouse starts using their policy, your premiums go away as well as theirs. And that can be really handy. The other thing to remember is to get as much coverage as you can comfortably afford, because the more you get, the more flexibility you have down the road. I used to be told that the average stay in the nursing home was 2 to 3 years. Now, remember that a lot of people might go in for a month or 2 or 3 for rehab. Those are not the same as going into the nursing home. So you could, if you need long-term care, need care for a year. You could need it for 5 years. You could need it for 10 years. There's just no way to predict that. So I do encourage people to get a 3 to 5 years minimum. Beyond that, I think for a lot of us, for the average American, you're just going to be priced out. Then it's going to get really pricey to get beyond that. And I don't even know if most companies are going to offer products for that. But getting as much as you can comfortably afford is important, because when it runs out, it's out. And then you have to worry about paying. There's also a little bit of an interrelation with the Medicaid program that I'll explain as I go on. But those are the two things that I guess it's three with the spousal thing, but the inflation rider and getting what you can comfortably afford are the two big ones. So you also want to be very careful and inquire very carefully about how in-home care is covered. A lot of policies, in fact, I believe probably almost all of them cover in-home care, or you can get that rider, but it won't necessarily cover in-home care 100%. It might be 50%. And a lot of the reason that a lot of people end up needing long-term care is it's just not feasible to keep somebody at home if you need 24/7 care or more than 8 hours a day or so at $30, $40, $50 an hour. The price of in-home care is very expensive, and when you're going into a facility, you're spreading the cost along a lot of people. Again, still thousands of dollars a month, because somebody's providing your room and board, the care, the 24/7 supervision, but it would be easily 3 times as much to stay at home with 24-hour care. So does that answer your question? Okay. And did you have a question in the pink? Okay. Anybody else have a question about? Okay. Certainly, I do have plenty of clients who are what I would consider to be self-insured. But what we do to kind of figure out if the clients are comfortable saying they're self-insured is look at several factors. And again, everybody's situation is different. We look at what assets they have, what types of assets, what pensions and income they have, whether they're married, whether they have kids, is their goal to leave an inheritance to the kids? I've had clients whose kids have outdone them by far, and they say, you know what, my kids are off making, setting the world on fire. They don't need anything from me. So if what I have pays for my care, I'm fine with that. My kids are fine with that. I consider myself to be self-insured. I sometimes have married couples, for instance, or even a single person with really good pensions. But I look at this with married couples as to the income, because if we have enough income to probably pay for care and don't have to dip into investments and savings into the actual nest egg, then we can consider that to be self-insured. But if you've got 2 people at home, it's not enough to say, oh yeah, we're going to have $10,000 a month to pay for dad's care. Well, what's mom going to live off of if one of the parents goes into care, one of the couples? How are we going to support the other person at home? So looking at the income and the projected cost of care, if it looks like there's enough income to pay for the care, then we can consider self-insured. So there's a lot of different ways to look at that. Self-insured doesn't mean the same for everybody. But I do still encourage people, even if they think they're self-insured, look at the long-term care insurance, because we really don't know where the costs are going. And even if you have investments, especially if you're relying on investment income, you never know where that's going to be. For folks who are not self-insured and don't have long-term care insurance or don't have enough, really the only other option is the Medicaid program. And One of the myths out there is that Medicare will pay for long-term care. Medicare is the federal insurance program for people who are disabled and have been receiving Social Security for at least 24 months or are 65 and over, whether they're disabled or not. So that is the insurance program that you pay premiums for, and it will pay for rehab stays of up to 100 days, but not necessarily a full 100 days in every situation. In some cases, the care through Medicare ends after 30 days or 43 days or 67 days. And it depends on how the person is progressing and what they are deemed to need. So if you need long-term care on a permanent basis, Medicare is not going to pay for that. It's for things like if you've had a stroke and you need physical therapy, occupational therapy, you need physical therapy following a joint replacement, often a hip replacement. Maybe you've had a heart attack and need cardiac rehab, and these things cannot be done at home. You need them in a long-term care setting. Medicare may cover even all of that if you have a supplement. The one thing to remember is that Medicare doesn't necessarily cover the entire cost of the rehab stay because you need a supplement to cover the copay. So the longer you're in for a rehab stay, the less of it Medicare pays. So it's really important as you reach the age or the situation where you have Medicare that you're talking with your insurance provider about getting the right supplement as well. And Medicaid is a needs-based program that is funded largely through the federal government. And you've probably heard a lot about it and Social Security in the news lately, not to mention some Medicare as well. But it is administered by the states. So different states have different rules within the kind of federal umbrella. The feds say your rules have to at least cover this, and you can't go outside these parameters. But one of the myths, and I shouldn't say just one of the myths, but one of the areas of myths that I deal with a lot is somebody will say, oh yeah, I know all about that because my aunt was in the nursing home in Texas or my aunt was in the nursing home in Indiana. Those states' Medicaid programs, even for long-term care, are different than Illinois. And even within Medicaid, you have a lot of different programs. You have community and home-based programs, you have long-term care, you have straight medical insurance. And it's important to remember that we're talking in the discussion this evening specifically about the long-term care program. That's all. It has its own very specific rules. But in some states, for instance, Texas and Florida, the state laws do a lot to protect your assets. That's why OJ moved to Florida. And that's why people move down there. Florida has pretty liberal asset protection. So even if you file bankruptcy, more of your assets are protected. Illinois, pretty bare bones. So in Illinois, if you need to apply for Medicaid assistance, your retirement is at risk because IRAs are not protected. 401ks are not protected. And people say, but I have to pay tax because I'm too young, or I have to pay a penalty, or I'm going to, this is all going to get eaten up. Are you kidding me? I saved all of this. I'm not kidding you. The basic rule in Illinois, without going into all the, loopholes, as it were, is that if you can liquidate an asset just for the asking, whether you have to pay a penalty or whether it's taxable to you, it's an available resource for your long-term care. And the state basically says, we don't want people who can't take care of themselves at home because they're elderly or disabled out on the street. We want people to have care and to be able to be well, or as well as they can be. But we're going to be the payer of last resort because the way our system is structured, we can't pay for everybody. So we're going to set some requirements for people to spend down their assets to a certain level. And once those assets are spent down, then we'll step in and pay. And that's where all the loopholes come in, is how do you spend down the assets legally? Because there's plenty of ways to do that, just like with tax planning. How many of you just tell your CPA, I'll pay whatever. Tell him I don't even want my deductions. Don't worry about that. Just put my gross income on there. Tell me what check to write and we'll be done. Nobody does that. And the same thing with the Medicaid rules. If you plan ahead, you can look and see what exemptions you might have. You know, they're not deductions per se, but there are different strategies you can use within that. So when folks come to me for nursing home planning and they've either gotten some long-term care insurance and are worried that it might not be enough, they can't get it, they know that Medicare isn't going to pay for the whole thing, and they think, boy, you know, I don't want the family farm to have to get sold to pay for my care, or I want my kids to still have an inheritance, or in a lot of cases I see, I've got a disabled child I want to take care of. Well, that's one of the loopholes. If you plan properly for a disabled child, which you should be doing if you have a disabled child, regardless of whether the goal is also to protect your assets from nursing home care, the law allows you to put that child ahead of the state. And basically the state says, we understand that we've got two people here who might need our assistance. So we're fine with you shoving some of your assets over to focus on your disabled child or other loved ones, so that we know that they're taken care of. And then that will kind of speed up your spend down.
This is an ABLE account under those exclusions?
An ABLE account, not necessarily. And ABLE accounts are under Section 529 of the Internal Revenue Code. And I'm sure all heard of Section 529 plans for college savings. Your IRAs are also under Section 529. That's basically where all of your tax advantage savings are. And an ABLE account is for achieving a better life experience. And it's an account that can be set up to save for someone who is disabled before the age of currently 46, but they're going to bring that down, I think, not until next year. So that's, you've got to be disabled before a certain point in life, and then an ABLE account can be used. And there's a lot of restrictions on that, only so much per year, just like with gifting. There's a maximum on ABLE accounts, and there's also a required payback provision. So they're not a one-size-fits-all saving plan, and they don't always dovetail with nursing home planning completely. Usually we're going to use either a direct gift if it's somebody whose benefits won't be at risk, or a sole benefit trust. And the law requires that we do things in a certain way. So we have to check a lot of boxes when we're doing this planning. But go ahead.
How likely are you to be able to get long-term care insurance if you already have a diagnosis?
Depends on the diagnosis. One thing to remember, and one of my insurance buddies told me, long-term care insurance is health insurance. So your health buys it, your money just pays for it. It's what he told me. And I liked that. I mean, it's because I don't think it's too glib. It really is a health insurance product. And for that reason, one thing that's become very popular over the last probably 15 years or more even, are hybrid plans which are life insurance plans with long-term care riders, because those are life insurance products and they're easier to underwrite. But if you are on oxygen, if you have a diagnosis of dementia, and if you have certain levels already of difficulties ambulating, you may very well and are almost certainly not to be likely to get long-term care insurance, at least traditional. You might still be able to get long-term care insurance with a rider. And so it's really important not to just discount yourself, because again, it doesn't cost you anything other than your time to get a quote, and to shop it around. I'm trying to think of, diabetes is one people ask me about a lot, but I've had a lot of friends with diabetes be able to get long-term care insurance. So but oxygen, I've been told, is still one of those that's going to make it really difficult if you're on oxygen. Go ahead.
maybe you're going to speak about this, but I mean, just to hear about Medicaid asset protection trusts, then my understanding is that's an irrevocable trust. If anything is left over and it could be inherited, and then presuming, let's say you have a large number of assets or investments which would be applied, which you could get, say, step-up basis for a survivor. If you put that in an irrevocable trust, my understanding is you won't get step-up basis. So in which space you kind of having to decide, is this asset, do I want to protect the asset or I want to protect the potential step-up basis down the road? And, depending on the size of that step-up basis, that could be a different decision.
I'm going to go back to the Medicaid rules because that's what the Medicaid Asset Protection Trust is built around those. So one of the rules now across the board, because of the federal law that all of the states were required to adopt by a certain date, so Illinois did it last, is that the look back period is no longer 3 years. Years and years and years ago, it used to be 3 years. It is now 5 years. I routinely get questions asking, isn't it 7 years? I still have no clue where that comes from, but that myth is out there. It's 5 years. So if you have to apply or choose to apply because you've used all your loopholes and exemptions, just like with tax planning, if you choose to apply, the state says, that's fine. But remember, we're the payer of last resort. So to make certain that you've abided by all of our rules, we're going to look back into your finances 5 years. That means that we're going to require every statement, even on accounts that were closed in the last 5 years, we're going to have a copy of every statement. We're going to ask you for proof of every transaction, right now over $1,000. So we're going to ask for copies of canceled checks, receipts, bills of sale. So as you go along in life and you think, boy, in the next, 5 to 10 years, maybe I need long-term care, start keeping the best financial records you've ever kept because somebody is going to need those. And it's really not fun for anybody involved if you do need care and they have to go into your basement, which has flooded, or where your cat decided to pee on the box of everything. Scan things in if you can and keep them safe and where people know where they are. Don't expect people to go on a hunting expedition. So one of the rules is that in Illinois, again, I'm talking specifically about Illinois, if you make any transfer for less than fair market value in the 5 years before you need care, the state is going to consider that to have been done for the purpose of qualifying for Medicaid, and it's going to issue a penalty. And there is a legal presumption that this was done. It's not illegal to do it. You can give away your money. There's nothing illegal about that. It's just the consequence may be a penalty when you do apply for Medicaid, which means that until you are in a nursing home and otherwise eligible for Medicaid, which currently means that you've spent down to $17,500. If you have a spouse at home, the spouse at home can keep the house, car, those are exempt. And there's some other less usual exemptions, and a little over $135,000. The spouse's ceiling is going to go up every year for the next several years. Right now, the spouse or the single person in the facility is at $17,500, and that's going to stay that way for a while. But the state is going to make sure that you haven't made those transfers for less than fair market value, or it's going to find them and add them up. And transfer for less than fair market value means, oh, but I sold my car to my nephew for $1. Well, but the car was worth $5,000, so you made a transfer for $4,999. Don't think that you can just put things in an account jointly. Well, I moved everything to a checking account and put my kid's name on it, so it's protected. No, it's not. It's your money. You might have given your child some access to it, but my rule to people in general for estate planning is never jointly title assets with anyone you're not married to. And even if you're married to them, make sure you trust them. And otherwise, in a business relationship with a written agreement. Other than that, there is no purpose served in almost any situation for having joint title on assets. If your kid has to file for bankruptcy, The bankruptcy court is going to pull that checking account in, and it's going to be up to you to prove that it's your money. You may end up hiring a lawyer, or if you're already disabled in somewhere, your kid's going to have to go through some more rigmarole getting information, and it can be a real hassle, and nobody needs that. Also, if you put your kid's name, it's usually a kid, sometimes a niece or nephew, put your kid's name on something, what does that mean? That's not a legal term. Have you jointly titled it? Have you just made the child a signatory? Is it payable on death to that child? We need to see the signature card to know. If it is joint titling, all you have done is given that child access to the entire shebang, not just half of it. Legally, they could say, I'm going to the golden nugget and I'm going to close out that account and take it down to zero and take every money and gamble it away. And they haven't stolen because it was legally theirs. So be very careful about joint titling and understanding that it doesn't give any protection. That's another big myth. To get the protection legally for your assets, generally you're going to have to take action more than 5 years in advance, because almost anything you do is not going to involve a sale. It's going to involve transferring to someone else or to a trust, and that trust isn't going to pay you. The trust doesn't have any money. It's only going to have what you put in it. Your child isn't paying you for these things. Or if you decide you're going to sell something to somebody, make certain that you're selling it for fair market value and that you're keeping all of the records. For the Medicaid trust, these are the Medicaid Asset Protection Trust, or MAPT, is a pretty common term in the nursing home planning world. Sometimes people call them income-only irrevocable trust. There's some other different names. Sometimes people call them family dynasty trust, or they make up little names to kind of sell them. But I just call it what it is, Medicaid Asset Protection Trust. Those are irrevocable trusts, but not all irrevocable trusts don't give you a step up in basis. You can create a Medicaid trust as a grantor trust. What that means is that the trust is considered to be part of the grantor's estate. So if I set up that trust for myself to put the family farm in or my other assets, I'm the grantor. I am granting the property to the trust, giving it away to the trust. And I can keep that in my estate, which means that any property in it does get a step up in basis when I die. That's a tax concept, and it's important, because if I put the family farm into a trust and my kids inherit it 20 years from now, they're going to want that step up in basis, because if they have to turn around and sell it, or they desire to sell it, they're going to want their basis in the property to be the basis on the date of my death, not 20 years before, assuming that farm prices keep going up, because obviously for the last many years, farmland has just kept going up in value. And there are plenty of other assets that people put into Medicaid trust, which are appreciating assets, which are going up in value. But you can create that as a grantor trust. And those can be done in some different ways. The idea of the Medicaid trust is that's the kind of trust you use more than 5 years before you're going to want to apply for Medicaid to get your assets into that. They're no longer going to be considered your assets. Somebody else is going to be in charge of them as trustee, often one of the kids. And you're going to get probably just the income. A lot of times you're not even going to actually get the income off of the trust. So when you apply for Medicaid, you can say, that's not mine. It's up on a shelf and I have no access to it, and it doesn't count. It is not an available resource for my Medicaid application. So it doesn't count towards my $17,500 that I'm allowed to keep, and it doesn't count towards my spouse's $135 and change that they're allowed to keep. So does that answer some of it?
Yeah.
Okay.
Long question.
Okay.
Presuming you go through some machinations and you apply for Medicaid support, my understanding is that only certain certain nursing homes would accept that. Can you apply towards private nursing home and add the difference, somehow? Does it kind of, I guess, what are the pros and cons if let's say you could in theory afford something that's not paid for by Medicaid? What are the pros and cons to going through these machinations to qualify for something when you could in theory afford something else?
Well, and this is one of the choices that you make is, am I only certain facilities will accept Medicaid, and they have to be licensed by Medicaid and approved. And even within those facilities, they're not all 100%. They have Medicaid beds, we call them. So they will, and they have to put on file with the Illinois Department of Public Health a map of the facility showing every literal bed. So if there's a double room, 2 beds, one bed in that room might be a Medicaid bed, one bed might not be. Usually they'll have like a wing that is a Medicaid wing, and they are required to put a map so that you can go in there and see how many Medicaid beds do they have, which ones are available. It's supposed to be transparent. It's not always that easy. A lot of times we find we have to do a FOIA request. But in our small towns in Illinois, it's still reasonably, I won't say easy anymore, but it's not the worst thing in the world to find a Medicaid bed. But you have to actually be in a facility in a Medicaid bed to apply for Medicaid to get approved. You can't apply ahead of time. You can't say, oh, we're going to put mom in next year, let's apply now. That doesn't work. It's not like it's a stipend. It is a reimbursement. So the rule is that, because you hear people say, oh, they take my check. Well, they don't really take your check. What they say is, another part of the deal is we're the payer of last resort. So you're going to apply your income, and there's always loopholes, there's always rules there, to the cost of your care. And then we're going to pay the difference based on the Medicaid rate, which is the rate that we as the state have established as what we're going to pay. We get to dictate it because we're the state. So the rate that we're going to pay for the care per day, and whatever your income doesn't pay for, we're going to pay for. So the other, aside from assets, the other side of the coin is that if you've got a $10,000 a month income and you're in a Medicaid facility in a Medicaid bed that only costs $7,000 a month, you're not eligible for Medicaid because you can pay for it. So the state's not going to. And that's a big deal for married couples in particular, because let's say you've got excess income. You want to have it so that one spouse is eligible, but you got to have enough left over. Did I answer all of your question first, or getting there? Okay. The VA has a program which looks nothing like Medicaid, called Aid and Attendance, which is a stipend. There are income and asset requirements for it that are not the same as Medicaid. It's fully federal. It's not state. The way they calculate your income is different than Medicaid is pretty straightforward. The VA calculates income and assets differently. And it is a stipend, so it's not a reimbursement. So no matter what facility you're in, basically they're looking at, do you meet our income and asset qualifications, and then what is the cost of your care versus your income, and up to a maximum will give you a check for what you can't pay for. So if the cost of your care is $4,000 a month and your income is $3,000, and this includes in-home care too. If you meet certain requirements, the VA will say, okay, here's a check for $1,000. And the maximum for a veteran is just under $3,000. Those numbers change every November. A widow of a veteran is also potentially eligible, but to get the in-home care, you basically have to be homebound, unable to, you need the aid and attendance of another person to be able to remain at home alone. Or if you're in a nursing home, that's going to qualify. I don't use the VA benefit as much because, as you can imagine, not even everybody qualifies, just because of when women have join the forces and become veterans and at what age most of them are. I don't think I've ever had a female client have aid and attendance yet, but that wave is coming. So we're usually just dealing with male clients for that. And again, you have to meet certain requirements. And for some people, for nursing home care, if you add the maximum stipend to the income, it still doesn't pay for it. So we're still going to look to Medicaid. And the programs are kind of mutually exclusive too, if you're in the nursing home. So that gets really troublesome. No, I was going to say we should take this show on the road. You're interviewing me. This is good.
Well, I have another question regarding for a lot of negative experiences, Medicaid payouts for these specific reasons. Another one has to do with reimbursing home care. For example, you can find very experienced home care people for $20 an hour. But apparently many of these, like the insurance or Medicaid or different things, require like certified nurses.
Yeah, and that's
twice as much.
That's a different program than the long-term care program. That's the, for Medicaid purposes, that's the community care program. And as long as the state, you meet certain requirements, the state sees that you can be maintained in your home with a level of care that doesn't exceed X, it makes more sense for the state to pay that. But once you need too much care, it's more economical. I shouldn't say less expensive, but more economical to have you go into a long-term care facility. So what we're talking about is the long-term care program. The community care program is different and has some different requirements. So it's a very tangled web, if you want to call it that.
Well, you mentioned like if a spouse goes into a nursing home, the other spouse maintain $135,000.
Not maintain it. And I do want to make this clear: is if you need long-term care and you apply for Medicaid, you have to keep your assets below 17.5. That means on the last calendar day of every month, you have to have less than 17,500 in countable assets. That's cash in hand. That's cash in your little nursing home account where they might pay for your hairdresser or something for you. That's your bank account. That's there are some certain other assets. It might be a little savings account you have for your funeral. There are a lot of different ways the funeral can be paid for, exempt and non-exempt. And it's even going to be the cash value of life insurance. That's one that gets a lot of people, is not realizing that because you can ask for that cash, you can ask for a check and it's yours. So that counts as well. But you, at the last calendar day of every month, you have to be at 17.5 or under. The spouse only has to be at the limit at the time of application. So if my spouse is in the nursing home on Medicaid and we're applied in the next year, my mom dies and I inherit $5 million, technically my spouse is still eligible. But this is where the income can come in. My assets are fine, but as the spouse at home, I'm allowed to keep just under $4,000. It's $39.48 this year. It'll go up every year a little bit each year for the next several. I get to keep that $39.48. So let's say that I was a stay-at-home mom, like a lot of my clients of a certain age were, and I worked outside the home a little bit once the kids grew, so I've got $1,500 a month in Social Security. But my husband has $2,500. Well, I can keep almost all of his Social Security to bring me up to that $39.48, meaning that his income largely isn't going to get paid to the nursing home. It's going to get paid to me. But if I inherit $5 million, presumably I've invested it or done something and my income will probably go up. Or maybe I'm the husband and I've got the larger income. Maybe I've got a $6,000 a month income. And so my wife's $1,500 is going to pay for her Medicare premiums. It's going to pay for her supplement, maybe her prescription plan. She gets to keep $60 for a personal spending allowance, and anything over that is going to get paid to the facility. My $6,000 a month, I don't have to pay the $2,052 over that $39.48 to the facility, my excess income is subject to this sliding scale the state has. So I'm only going to pay a very small amount of that to the facility, not 100%. So a spouse at home with excess income is going to get to keep a lot of their excess income. So it's, people, but I still have to pay the nursing home. Yeah, but you don't have to pay them $7,000 a month. You might be paying them, $200 or $150 or even $700. But I'd rather pay $700 than $7,000, and it keeps you from getting wiped out. And again, the spouse at home can have excess assets after the fact. Okay. Okay. And I'm trying to give detailed enough answers to make it clear that there are very stringent requirements, but I could drill down. I'm supposed to speak for an hour, and we could be here all day. So, sorry.
In talking about the nursing home, so and maybe I'm clueless about this, but the quality of care, as you had mentioned, the beds need to be identified and Medicaid versus not. Does getting long-term care give you better quality? It's not
supposed to. The Medicaid rules require that you get the same level of care. And of course, the Illinois Department of Public Health comes in and inspects the facilities, and there's a minimum level of care you're supposed to get regardless of what your payment source is. That is to say, not all facilities are created equally. And there are some private pay facilities that are only private pay, and they are structured to cater to people who want extras. Just like if you can go to a Cards game. Please tell me you're not Cubs fans. Anyway, I'm kidding. I come from a family where we're divided. But if you want to go to a baseball game, you can sit in the bleacher seats, or you can get one of the skyboxes. And that's the way right now our economy is structured, and that carries over to almost all aspects of life. So, but the bottom line is that I have found over the years in our small towns especially, you've got just even enough community oversight, and when there are family involved who can advocate for you, your quality of care shouldn't suffer. In other words, you may not be in the skybox, but you should at least be comfortable enough on your bleacher seat, and the vendor ought to come around often enough with your Diet Coke and your popcorn and stuff. Again, another part of the planning that's really important is doing your basic estate planning. You've got to have, at a minimum, powers of attorney in place. If you have not done asset protection planning and it becomes appropriate for you or desirable, and you can't do it for yourself, you want to make sure that someone is appointed who can do it. If you take the statutory short form power of attorney out of the law books and fill that out, you will not have that person, because it doesn't give them the powers to set up a trust. They won't have the power to set up a trust on your behalf, even with you as grantor. They can stand in your shoes. If you have it drafted properly with extra powers, they can do that. They can set up a trust, they can fund it, they can make gifts of your assets. Because that's another myth out there, is that it's illegal to give your assets away in the 5 years before you apply. It's not illegal, it's just that there's a penalty. And then there's often a mix-up between the IRS rules and the Medicaid rules. There is not a limit on gifting. There is no legal limit on gifting. What there are consequences. And the IRS, it serves one purpose in life, and the Illinois Department of Public Health serves another. So the IRS says, oh, if you give away X dollars, we won't, per year, which currently is 19, we won't make you pay a gift tax. And by the way, that's not all there is to it, because right now it's almost $14 million per person lifetime. So if you have $20 million and this year you say, oh, I'm going to give $14 million of it away to my kids. Well, you've just used your lifetime coupon, but you still don't necessarily have to pay a gift tax as long as you don't give away beyond that for the rest of your life. So there's no legal limit to gifting. There's just consequences to different circumstances and levels of gifting. And on the Medicaid side of things, the consequence is any gifting will result in a penalty, and it's dollar for dollar. So if today I give my kid $10,000 he wishes, and tomorrow I had to turn around and apply for Medicaid, the state is going to say, look at my stuff, and they may say, oh yeah, okay, we're going to pay as soon as you pay the first $10,000. Now, for some people, this can work out. I do a lot of what we call half-loaf plans, where I do very specific calculations. We get all of your assets identified, get them valued to the penny. I do the calculations based on the cost of your care, the assets, the income, everything, and we figure out how much you can give away, exactly what the penalty will be, and then there's a way we pay for that. And remember that you've got or almost everybody has income of some sort. So that dollar for dollar really isn't a dollar for dollar because the income kind of alleviates some of that. And for paying for the penalty period, we use either a specialized Medicaid qualified annuity or a promissory note to usually one of the kids, as long as they're trustworthy to adhere to it.
You can put assets into a Medicaid asset protection trust. What type of limitations exist for, let's say you want to sell a specific investment, this investment property, and you want to invest it in something completely different. What kinds of things can you do and not do if the things that are once they're in?
Once they're in the trust, the trustee, if the trust is drafted well, should have the power to buy and sell assets, to even mortgage, to take out loans, to give loans. Loans are trickier because the trustee is a fiduciary and should be abiding by basic fiduciary rules and principles. And so you don't want them to go long on Bitcoin necessarily in a trust. I had somebody come to me once complaining because they had inherited from a parent in a trust when they were younger. When it came to fruition, at a certain age, they were given all the money, and they said, well, I could have made more money than this. Well, coulda, woulda, shoulda. The trustee was bound to invest fairly conservatively, and most will. So they may not make loans. They may not take out loans unless, like if it's a farm for an operating loan, which is pretty typical and acceptable. They'll make prudent investments, and it's the prudent investor rule. But yeah, if they decide, yeah, Dad had some rental houses, the market's good, it's time to sell those because, whatever reason, they could conceivably sell them and then invest the money in the stock market or something. So but it's done within the trust, and remember, it's not your asset anymore. It belongs to the trust. So the trust is going to be the seller. The trust is going to keep the money and be the owner of the new asset. Just kind of standing almost in your shoes, if you will.
Okay. I was late, but
that's good.
Okay, so if you set up saying the trust in your kid name, and you put like the house that you own, and with whatever other assets in the trust, you have to do that. How many years do you do that?
More than 5, at least 5 years, I'll say. So I try to obviously do it more than 5 years ahead. And if you're putting your own residence in a protective trust, you can do that, but you want to make sure that the trust is drafted properly to be clear on who is paying the real estate taxes, and that you have the right of occupancy, and that you're paying the utilities and things like that. So there would need to be some special language in that. My now former law partner, because he got to retire, he used to routinely have people put the house in one trust and other assets in another, because of the right of occupancy. I do that in one trust. I use a different program than he does to facilitate my drafting, but there's basically more than one way to skin a cat. But the important thing is that you have things made very clear as to what the rights of occupancy are, and the grantor's retained rights are, and that sort of thing.
Okay, and one more question. Okay, so let's say the person that's going into the nurse's home long term. Is there like IRA? Is that protected?
No, I think you came in after that. We're in Illinois. If you want to protect your IRA, I think you can still do it in Texas, maybe Florida. I don't practice in either one of those states, so don't quote me. But in Illinois, any asset that you can liquidate for the asking, just because you say so, even if there's a tax consequence, even if you lose part of your money, even if you pay a penalty, it's available and it counts towards your asset limits for Medicaid.
Okay. So it put the IRA like into the trust of which is
You-
buying your
That's a really good question. I think we can do a road show. You can both interview me. So, an IRA is an individual retirement account and it can only be owned by an individual. A trust cannot own it. So sometimes what we do with IRAs when we're planning is what's called a like kind exchange. And if you've ever dealt with real estate, if you've ever heard of a 1031 exchange, which is where you have to follow some very strict IRS rules about how things are staged. You can sell one piece of property, buy another. There's a section 1035 exchange where you can exchange one financial product for another. It might be an IRA, it might be a life insurance policy, an annuity. So some people find that the numbers work out for them to exchange their IRA for a specialized annuity that won't count. It'll provide an income stream towards the care, but the asset won't count. And that's a very individualized decision because, again, everybody has different assets. Even if your neighbor is the same age as you, the same gender, you're both married, you both have IRAs, is somebody's going to have more in the IRA, somebody's going to have more in life insurance, more in a brokerage account, the house may be worth more. Everybody's picture is going to be different enough that you really have to crunch the numbers. So I did make clear earlier on, this is not like a do-it-yourself project, but it's to make sure that people understand. Because I did have a person come to me once years ago who had been a little bit misled or misunderstood something and thought that their IRAs were protected and found out they weren't. And they had been going along thinking the IRAs were protected, and then the spouse needed care, and we lost a bunch of the money, or we didn't. That person did. I was able to save some of it still because even if mom or dad's been in the nursing home for some time, as long as there are still assets to protect, there's often something we can do. But we really want you to have that power of attorney for property that gives somebody the right to do everything they need to do, which the short form doesn't. Because if we don't have that, we have to go to guardianship court, and we're not guaranteed to get the guardianship. In most cases, yeah, if they're already in care, but also not necessarily guaranteed that the judge is going to let you do the planning because you're playing with somebody else's money. And some judges will allow you if there's proof that no, if mom were alive, she wouldn't want all the money spent on care. But if you can't satisfy the judge that you're doing the right thing with the person's money, they may not let you. So the power of attorney lets you choose who is going to be in charge of your money. The court doesn't do that for you then. And also what powers they're going to have. So you still get to be in control even if you're not at that moment able to call the shots. But again, it's a very individualized situation, and the IRAs are trickier to plan with. And of course we see a lot of them because I'm in a generation that was raised by a generation of people who were like, let's put it all in the IRA because there's all this stretch, and it's basically we're creating dynastic wealth. Secure Act came along in 2020, and if you've heard of that, I call it the Insecure Act because we took away all that time value of money for the people inheriting IRAs. Other than the spouse, disabled person, somebody not more than 10 years younger than the owner, there's eligible designated beneficiaries. Everybody else has to take it out within 10 years or less. And so you lose a lot of time value of money. IRAs have changed, but the generations that we're largely seeing needing care and needing the planning, a lot of them have a lot of money in IRAs, and it does make it tougher to plan because you can't put it in a trust.
So way out there, but what if the investment change that you want to make in the trust involves purchasing something in another country?
Prudent investor rule, probably not going to be able to do that.
Because the U.S. is doing good investment.
Well, things are more at risk in some countries. I mean,
Sir,
yeah,
just because there's no jurisdiction.
Yeah, that's going to be trickier. As an attorney, if I was representing a fiduciary, a trustee, and they said, "Oh, we want to go buy a villa in Italy," I'd be like, I'm not going to. I'm going to tell you you can't do that, and I'm not going to represent you in doing it because I think it's too risky.
Ultimately, as I say, if you give a POA and you structure it in a certain way, there's no reason why you need courts involved in any of your.
No, but you still have to make prudent decisions. The courts aren't involved, but you always have to think, what if? What if I am held to scrutiny? Will this pass scrutiny? Did I do the right thing? And an honest mistake is one thing. You know, just simple negligence like, oops, sorry, I didn't, for some reason I didn't see that things were going to tank and I could have sold it the month before and I didn't. Well, nobody sees the Spanish Inquisition coming. There are certain things you can't predict. But like I said, going and saying, well, I'm going to put it all on Bitcoin, in the financial world, that's probably not considered the most prudent investment. I know some people have made money on it, but it's not like you can't look at it and say, well, every 10-year period in Bitcoin has made money, whereas every 10-year period in the stock market has,
I mean, let's say, you cut your losses with Medicaid, paid nursing home in the U.S., and you want to pursue retirement in another country where your cost of living is going to be 1/10 what it is. And so then you need to be able to move assets to that country.
Well, you don't necessarily need them to be in that country to be accessible. With all the electronic access to money, you don't necessarily have to move your money with you. And interestingly, I was and may resume looking at retiring overseas. And there was a country I was looking at. Cost of living was great. And fun fact, my long-term care insurance will pay for nursing home care in that country. That sounds good, but the next step I have to do is check out the nursing home care. Do I want to be in a nursing home in another country? Because I might be better in small town America. And I don't know the answer to that question, but there's a lot of levels of consideration there.
There are places where you could create your own nursing home for the cost of really get single parents.
Yeah. But it's going to be, these are all very fact dependent things. So, yeah. And I do apologize. There was a gentleman back there who hasn't asked a question yet, and he had his hand up.
Explain his like or like exchange. Imagine specifically INA to anybody. How is it ridiculous?
If you are using there are Medicaid qualified annuities that meet certain requirements outlined in the law that will not count as your asset, but they will provide an income stream. And we use those as a strategy in certain situations. They're not a one size fits all, but they work for some people. So
when you say professional assets, I assume anything left over can be inherited.
Yeah, let's say that my spouse needs care and I have more than my $135,000. I can potentially get an annuity for me with some of my excess assets. It will have to pay out to me every month, and the income will count as mine. I may have to give part of that income, usually a pretty small part, to the facility to help pay for my spouse's care, but the rest is mine. Whereas if I kept it as an asset, I would have too much and he wouldn't be eligible. But if I turn it into an income stream, I get it back little by little. The investment may not be the same return, but if I've got, let's say I've got $250,000, that's like 2.5 years worth of care. That's not a long time. And that money is going to be gone very quickly. But if I can turn it into an annuity, and if I've got enough years left, because it has to be paid back to you within your life expectancy according to certain charts. So the older you are, the fewer years you have to get that money back. But I'm 55 years old. So if I do something like that, I'm getting the money back over quite a long period of time. It's not going to be that much per month. and I may end up not paying anything for my spouse's care.
Well, what is the average? What's the range of all the care here in Illinois, and what is the inflation?
We don't know where the costs are going. I don't think I can responsibly answer that, but I think you're easily in a lot of places. You're looking easily $6,000, $7,000, $8,000 for the least expensive care on up, and there are plenty of places that are $10,000. If you're looking at the skilled nursing care, now assisted living is less expensive, but it's also a different level of care. And in the white shirts,
That's just there for the card review with services, health and services did a survey that 2016, and they said if you're blessed to have a couple 65 years old in 2016 that live 30 years from now, they said the projected cost for both those people to be in a nursing home for 5 years was going to be about $1.9 million.
oh, I can imagine that. Yeah.
That's how, they're projecting
Yeah.
years, 9 years ago, 30 years from now for two people.
Yeah.
Same time for 5 years.
And we are in Illinois, especially the further south you go, the less expensive the care is. And so even between, Effingham and Champaign, there's you can see a noticeable difference in the cost, but you don't even have some of the same kind of facilities further south in some of the smaller counties. And the cost of care, of course, on either coast, if you're in LA or New York, cost of care is going to be huge compared to here. So if you look at national averages, 1.9 million doesn't shock me at all.
The memory care.
Yeah.
Odds are two people are going to be in nursing homes the same come 30 years from
Right.
now.
Right.
Be 95 years old and live to 100. That is something that they is. What about life insurance? You touch on
I actually did, and I apologize. I didn't talk that much about it, but it is the more common product anymore that I see my clients getting for a few reasons. One that I mentioned is it's not health insurance, it's life insurance. So it's easier to underwrite. It's easier for people to get. Yes.
Hey, there used to be a piece scope annuities actually used to have a policy that had one. They can't afford it.
Right. I will be very clear. I got really lucky because the one time I listened to my dad, I got a country policy back when they sold lifetime policies. Yeah.
They'll benefit a lot for curious. Till you got tax break.
Yeah.
That if you less than to have policies, that's
Yeah. And they used to, years ago, I used to be told as an elder law attorney, steer away from the life insurance with long-term care riders. But now that's most of the market because they can't afford it's harder to underwrite. People, even if they have a little bit of health problem, might not get a traditional long-term care policy, but they can still get the life policy with the rider.
Several speaker attachments. Care policies have the 10, 15, 20 years. There it start getting premium bills now.
Yeah.
And they just.
Yeah. And I've had a few clients. We are running actually past my time, but I've had a few clients run into that problem. Knock wood, not too many. But I think the life insurance with the riders are really where the market's gone. So I don't think so. I told you folks I could talk about this all day, but we did hit on a lot of the, I would say most of the big questions I get asked about, gifting limits, about insurance, about they're going to take my house. They're not going to take your house if you don't let them. And that's why you want to plan ahead, or you want somebody to have the ability to plan ahead. There's a lot that you can do, but the big thing is don't keep your heads in the sand, because really any of us in this room is at a pretty good risk of needing long-term care, just because we're an aging population, like you said. My grandmother lived to be 92, and she was convinced at 59 every day. Once she turned 59, she thought she was going to pass away, and we listened to that for years and years. And when they, and I'm not speaking ill of her. I miss my grandmother. I loved her so much. But when they called me one day 13 years ago and said, the doctor's calling us into the hospital, I asked my aunt, I was like, is it for real this time? I'll drop everything and I'll get there. But we've heard this so many times. This is the big one. This is the big one. And unfortunately, it really was. But she never would have dreamed to live until 92 because that's not what happened with her parents' generation. And it's just, I'm seeing a lot more clients in their 90s. I call him my favorite client. I know I'm not supposed to have a favorite, but we have a special friendship. Going to be 100 this year. We just got to make it a few more months, and I'm really excited. And I'm seeing that more and more. But he's also not the same guy he was on his 99th birthday. So, I'm not looking forward to our next meeting because we've got to have these tough conversations about what the next steps are, and that's just the reality of living longer. So. The more you face it head on, the more you're going to be able to protect yourself and to have stability. And it's not always about even getting on Medicaid. It may be the long-term care insurance, but it's also knowing that there is a plan and there's not going to be a lot of panic and questions if something happens to you. Because that's the worst thing in the world is your family not knowing what the plan is and not knowing what to do. So, thank you.
Mhm.